Hi, good night, everyone. This is Attorney Tharpe at ST Law Office, and I am coming in to talk to you, answer your questions. So go ahead and drop your questions in the comments. I want to hear from you. Your questions are my priority. So go ahead and put your questions in the comments. I just want to introduce myself to you. For those of you who don't know, I am U.S. Immigration Attorney Tharpe, and I help clients to get their green cards and their status in the United States. I usually come on every day to provide you information that I hope is helpful to you, especially if you're going through the immigration process. But the main thing is I am here to answer your questions. So no matter the topic I'm talking about, I want you to know that feel comfortable to drop any immigration related questions in the comments and I will answer them. So I usually come with a topic to talk about. Hi there, Teacher Steve. I usually come with a topic to talk about while the questions are coming in. So don't feel self-conscious about typing your questions in while I'm talking. I'm monitoring the comments, and as soon as I see your questions come in, I will go ahead and start answering them. So stop what I'm doing to answer your questions. So I want to talk about two ways to fix your immigration status if you're currently in the United States and you want a green card but you overstayed your visa or you came into the country without permission or without your papers. So I'm going to talk about two ways right now. And the first is I'm going to explain to you the process of applying for what's called the unlawful presence waiver. So the unlawful presence waiver, otherwise called the I-601 waiver, is a type of application. So Teacher Steve 37, what happens next after you send your I-485 to the immigration judge? So if you are going, it sounds like you are currently before an immigration judge in removal proceedings, and that of course may be your best hope. So in that case, the judge will usually schedule a final hearing. So usually you file your documents before you actually get to the individual hearing. At some point, usually during one of the master calendar hearings, the immigration judge will set a date to do the individual hearing. That's sort of like the final hearing, or I think many of you can relate to like a trial. So it's where everything is going to happen. Sometimes, just depending on how complicated the case, you'll have multiple individual hearings or you'll have one. So that is where the judge, you will make your case. It's sort of like the final interview. Hi there, South American dude, where you will make your case as to why you qualify for the adjustment of status process. And so the next process would be the individual hearing. But in more complex cases, the judge, of course, would instruct you or your attorney on what to do next. And if you are currently being represented by an attorney, you should definitely defer to your attorney because your attorney knows your case best and your attorney knows what will come next. If you are unrepresented, then I urge you to seek representation through that process. And you can also, so you haven't had the master yet, as it was postponed, of course, and that is very common in deportation hearings. But when you do have the master calendar hearing, it's usually there that the judge will speak to you or your attorney about pending issues as to even the viability of an I-485 and then move forward with scheduling the individual hearing. If sometimes maybe another master calendar hearing or the final hearing. But it all depends on the facts in your case, how complex it is, and what's going on. If you would like to seek representation and you are not represented by an attorney, you can always feel free to give me a call at 561-405-4889, and let's talk more about what's going on. So top man hunch. Hey, if you get your work permit renewed, does that mean you're eligible for a green card? So not necessarily. Sometimes you will get your work permit while the process is pending, and as long as the process is pending, your work permit will be renewed. However, if the final decision is a denial, then that work permit will become invalid and it will be revoked. South American dude, can someone keep their home country citizenship when they become a U.S. citizen, like a dual? Yes, so that is very, very common. If most people do retain their citizenship when they, so for example, if you're a green card holder, you apply for U.S. citizenship, that person can retain their two citizenships. So that's usually not a problem at all. We're welcome, Teacher Steve. So keep those questions coming. These are very good questions and I want to see more of them. So feel free and comfortable to continue to ask your questions. I am talking about how to fix your immigration status if you're currently in the United States and you're out of status, meaning you overstayed your visa or you came into the country without your status, without your papers. So I am first talking about the unlawful presence waiver. And that is a type of application for forgiveness for living in the country without your papers. Now, the main purpose of that waiver, seeking that permission, is because as long as you don't qualify for the adjustment of status, however, an adjustment of status, I mean you don't qualify to stay in the United States and apply for your green card, you can still pursue the green card by finishing that process in your home country. And the waiver gives you the opportunity to travel to your home country, go to the final interview, and not face the consequences of having the unlawful presence held against you. So top man hunch, how will I know if I am eligible for a green card? So that is a very loaded question. So one way is to schedule a consultation with me and we can talk more about what you qualify for based on your particular circumstances. But I can give you a quick summary. So you can qualify for the green card through an employer-based green card through family members. So if you have a U.S. citizen spouse or a legal permanent resident spouse, a legal permanent resident parent, or spouse, if you have a U.S. citizen, then you could qualify. A U.S. citizen sibling, you can qualify. However, keep in mind that the length of time that it takes to get the green card depends on who is applying for you. If you are applying through a U.S. citizen spouse, parent, or a son or daughter who's 21 and up, that is the fastest process. If you are applying through a green card holder spouse, that could be fast just depending on how far down you are on the wait list. If you're applying through a legal permanent resident parent, then that process you can expect to be, and you're over 21, then you can expect that process to be about 5 to 6 years. If you're under 21, then you could expect a shorter process. So it all depends. what you can do is you can give my office a call at 561-405-4889 and schedule a consultation. Now, right now it's after hours. You will get a receptionist, but that receptionist usually takes your information, and then the scheduling assistant will give you a call during the next business day, which would be Monday. Shanae Love 5, how long will it take for an asylum procedure to go through immigration court? So the process is backlogged. It could take, and it really depends on the court you're in and the caseload of the judges. It could take years. I've seen it span for years. So it all depends, unfortunately. So Top Man Hunch, okay, I will, and I'm looking forward to hearing from you. Hi there, Vanessa Field 4. It's nice to see you here again. So go ahead and keep dropping your immigration related questions. That's why I'm here to answer your questions. So in the meantime, I'm talking about how to fix your immigration status if you're in the United States. So I've been talking about applying for the unlawful presence waiver. And that is one way. So I'm going to try to summarize this very complex topic for you to understand. So the first thing is, if you don't qualify to apply for the green card while you're in the United States, and you are here, you overstayed your visa, you came into the country, but you have a family member who can apply for you, but you don't qualify to stay in the U.S. because you have been here without your papers. One way to fix that is to apply for the forgiveness through the waiver that will allow you to go to the final green card interview at the embassy in your home country. And when you attend, the officer with that approved waiver will not use your unlawful presence against you. So, hi there, Sandeep. It's nice to see you. Hi, Heavenly Ice Angel. It's nice to see you here again. So, how do I know if I'm eligible for status? So, it really depends on your particular circumstances, but the most common ways that one gets a green card is through family. So, through a U.S. citizen or legal permanent resident spouse, parent, or citizen son or daughter 21 and up, or through U.S. citizen siblings. But each of those can take, the length of time varies. The quickest way to obtain status in the United States is through a U.S. citizen or a legal permanent, a U.S. citizen spouse, parent, or a citizen son or daughter. So a spouse, a parent, and that parent, when you're doing it through your U.S. citizen parent, it has to be, you have to be under 21 and unmarried. Or, so spouse, a parent, if you're under 21 and unmarried, and a child, 21, citizen child, 21 and up. If you are not within this category, you cannot, if you're not within this category and you don't have your status, your legal status, then you will not be able to stay in the United States and apply for the green card. You'll have to pursue the green card at the embassy if a family member still is going to apply for you. So it's a complicated topic. So if you really would like to pursue the green card and you have a family member who can apply for you, so if you have other types of family members like a green card holder spouse or parent, then you, or a citizen sibling, a U.S. citizen sibling, but you're in the United States without your status, then you can go ahead and seek a consultation with me, and I can talk to you more about a strategy to pursue the green card. But chances are what will happen is if you are not the spouse, the parent, or the son or daughter 21 and up of or you're not if you don't fall within this category, you're not the spouse of a US citizen, you're not the parent of a US citizen, or you're not the child under 21 and unmarried of a US citizen, chances are, and you have not maintained your status, you will not qualify to apply for the green card, and the only other option will be to apply for a waiver and then finish the green card process abroad in your home country. So Heavenly Ice Angel, it is not in the news lately, and so it really is in limbo. We're still waiting to see what will happen with that. So I'll definitely give you an update as soon as I hear something. Mac Angel 1, what if I overstay because I am in fear of my life back in my country? So if that is the case, then you can definitely look at applying for asylum. Now, if you overstayed, you usually have 1 year from the time that you've fallen from entered. So 1 year from the date that you entered the country to apply for asylum, or you have to show an extraordinary circumstance that prevented you from applying with that time. So the clock is ticking. You can give me a call and we can talk more about why you're in fear of returning to your home country. If you're going to apply for asylum based on your fear of returning to your home country, one thing is you have to show that you're a part of a larger particular social group that is experiencing the same type of fear in your country, and that fear of persecution. They're being persecuted, they're being harmed, they're being threatened in your country. And so examples of this are people who are part of a religion that are being persecuted, being killed, being threatened, being economically damaged, being exiled because of their religion. So Heavenly Ice Angel, can my cousin sponsor me? No, unfortunately, cousins cannot sponsor. They don't qualify to sponsor people for green card. So keep those questions coming. These are all great questions. So Sandeep, my I-485 interview is, and hi there, Sexy Tommy. It's nice to see you. I'm doing well. It's the weekend, so that's always good. Sandeep Kumar, my I-485 interview is done on the 29th of September 2020, but I don't get my green card. How long of a wait more? So unfortunately, I would not be able to give you a specific time, but because I noticed that this is happening with other situations and the case may be in review. So what you can do is you can look on the uscis.gov website. You'll see case processing times and look for the office where you would click the office. So once you click case processing times, click on the office where you did your 485 interview. And then you will see the range of time that they usually take to process the green card applications. And then you can have an idea of how long it will take, but it's not a definitive, it just gives you an idea or an estimate. So Shanae Love 5, what would happen after the final hearing if your asylum case got denied? Usually you would either be ordered removed or you would be given voluntary departure, which is a little better than removal. But you'd be expected to leave the country after if you're ordered removed because your asylum case was denied. Now another thing is you could appeal it, and that would give you some more time. However, if the appeal fails, you would be expected to leave the country. So McAngel 1, if my husband is a green card holder, can he file for me? Yes, so he would be able to file for you. However, if you are in the United States and you don't have your status, then you would not qualify to apply for the adjustment of status, which is applying for it in the United States. The only way is to leave the country and complete the green card process at the embassy. And this is a good question because it's exactly what I'm talking about in order to apply for the waiver. So but here's the catch. If you leave the country to attend that final interview and you've overstayed your visa by more than 180 days, you will be denied the green card at the embassy and told that you're barred from coming to the United States for 3 years. And if you've overstayed by 1 year in the country, then it's going to be 10 years. So what you would have to do is you would have to apply for a waiver to be able to come to get forgiveness for overstaying, and then continue. Once it's approved, you could go to your home country for the final interview. So Mac Angel, you said, so I think you said you will die. Okay. So in that case, I would definitely want to talk to you because your case sounds a little more complex, and I would want to figure out what is going on to come up with a strategy for you and your husband. Because if you're in fear of returning to your home country, then we would want to figure out something that will work for you. So give me a call at 561-405-4889, and let's talk about all of your circumstances so I can advise you. Sandeep, you're welcome. Diva 9 Queen, it's nice to see you. So keep your questions coming. These are all great questions. So I basically covered the topic of applying for that waiver if you don't qualify to apply for the green card in the United States. Now that waiver, who qualifies for it? Because unfortunately, not everyone who has overstayed their visa can qualify for this. You have to have a U.S. citizen or a legal permanent resident, spouse or parent who will experience extreme hardship if you are not given the green card. And you will have to show that extreme hardship. The extreme hardship is not just a mere inconvenience of you that your spouse or your parent will experience. It's going to be something more severe. So for example, if your spouse or your parent depend on you to help to take care of them, if they have health issues, those that could possibly be an example of an extreme hardship. If they will suffer an extreme hardship, for example, if their health will decline or they won't have a caretaker if you leave them. So this is just one example of an extreme hardship, but it's not a comprehensive list. It could be financial hardships. It could be health-related hardships. It could be extreme hardships related to your parent or your spouse having to relocate to your home country with you in the case that you don't get the green card. So now what I do want to say is this waiver is very important to approach it with caution and strategy, because it is not a fill in the forms type of waiver. It is very much evidence-based, and you have to make sure that you provide the sufficient evidence in the best effective way in order for the officer to understand these extreme hardships and circumstances in your case. So that is one way to fix your status. I'm going to quickly run through another way, and this way will allow you to stay in the United States. Now, you do have to have qualifying relatives once again, and those relatives would be a U.S. citizen or legal permanent resident, green card holder, spouse, or parent. Or if you have a U.S. citizen or a U.S. citizen's son or daughter who's 21 or up. And if you're experiencing abuse, extreme cruelty, or mistreatment by these relatives, these one or all of those relatives, then you could apply for the green card on your own based on the mistreatment. And this will allow you to stay in the United States even if you came into the country without your papers in some cases, even if you overstayed your visa. And while you're waiting for the green card, you could apply and get your work permit in 6 to 8 months while you stay. Now with this one, it definitely allows you to stay in the United States, and it allows you to adjust status. Even if your husband or your parent or your spouse, I should say, is a green card holder. So empty chair, what about all the fees? So you can look at the uscis.gov website to look at the fees that you would like to know about. So I just had a child in the US and would like to get my green card. How do I go about that? So unfortunately, having a child alone wouldn't be enough to qualify for a green card. Your child would need to be 21 and up. So obviously you have a long time to wait. You would have to qualify through other means, so through another family member to be able to get the green card. Thanks, Sabana94, for sharing my live. I'm just looking through to make sure I didn't miss anybody's questions. So I just mentioned another way, and that's if you are being mistreated, if you're being subjected to extreme cruelty by a U.S. citizen or legal permanent resident spouse or parent, or a citizen son or daughter who's 21 and up. This is a confidential process. If you're married, you don't have to be divorced or separated to apply for this. Also, even if you're divorced, as long as you've been divorced for less than 2 years, you can still qualify for this type of green card. And the reason that I say it is one way, if you're going through this, empty chair, oh, you're great. It's nice to see a fellow Jamaican on here. So the reason I say that it is one way to fix your immigration status if you are experiencing this terrible thing is that you get to stay in the United States. It does not force you to leave the country to pursue the green card. So Shanae Love, can someone get a green card even after receiving an order of removal? So yes, but that's an extremely complex matter that will take legal expertise. So that will definitely, you will need to give me a call, and if that's the case for you, give me a call and schedule a consultation to talk more about strategies to be able to get around that order of removal and get the green card. It is possible, but it is also one of those complex areas that you want to make sure, first of all, I need to get all the facts to make sure to advise you properly and to do it correctly. So Latoya Henry, how long is the wait for work permit after submitting forms for adjustment of status? So generally, I would say prepare for a 6 to 8 month wait. It could be shorter. I've seen as little as 4 months. But it could, I always say, be prepared to wait for 6 to 8 months. So that is all I have today, and I am here every day. So if you have your questions and I didn't get to your question, go ahead, hang on to it and look out for me. If you're not following me, follow me so that when I come on again, you can you'll get notice that I'm on live and you can hop on. So I usually find a time of the day that I'm free. So unfortunately, I don't have a particular time I come on, but I do have a time range which is anywhere from 7 to 10 p.m. So it's always best to just follow me and get notice. If you'd like to schedule a consultation with me, you can check out the link in my bio, where you can learn more about me and get my contact information. You can complete the contact form on my website, and that would allow us to contact you on the next business day. So the scheduling coordinator will get back to you on the next business day, which would be Monday. Or you can call the number, and then after hours receptionist over the weekend, from now until over the weekend, will answer, take your information, and on Monday we'll give you a call. So thanks everyone for tuning in. I'll see you tomorrow. Have a good night.